Hello, everyone, and welcome to Uncivil Law. For today's case, we have the case of Leo Lech versus the city of Greenwood Village. In this case, the police were chasing a suspect who barricaded into a home, not his home, and the police extracted the suspect, but not before causing substantial damage to the home. The question is, does the government have to pay for the damage during this police raid? So we're going to read the facts and comment as we go. So let's get started with this. Leo, Alfonsia, and John Lech, the Leches, sue the city of Greenwood Village, the city, and several of its police officers, the officers, alleging violations of the Takings Clause of the Fifth Amendment. As you may remember, the Fifth Amendment provides in part that property shall not be taken for public use except through fair compensation. And so that is the text here. A person's private property was taken, potentially for public use, and the question is, does the government have to pay with fair enumeration for the taking? In support of their Taking Clause claims, the Leches allege violations violating their constitutional rights, first by damaging the Leches' Colorado home during an attempt to apprehend a criminal suspect, and later by refusing to compensate the Leches for this alleged taking. The district court granted the defendant's motion for summary judgment, concluding in relevant part that when a state acts pursuant to police power rather than the power of eminent domain, its actions do not constitute a taking. Because the officers destroyed the Leches' home while attempting to enforce the state's criminal laws, they acted pursuant to state police power, and any damage to Leches' home therefore fell outside of the ambit of the Taking Clause. So we see the district court granted a dichotomy here. On the one hand, there was the issue of police power. On the other hand, there's the issue of eminent domain. Police power doesn't just mean police officers. Police power generally means the power of the government to basically do anything. For example, fire function is a police power. Ambulance authorities run by the government are police power. Regulatory issues are police powers. Anything that allows the government to produce any kind of law or regulation or offer any kind of service falls within the scope of police power. It is the general power of the government to do stuff in the broadest sense. So that is contrasted with the more specific power of eminent domain, where private property is being taken for public use in terms of the Fifth Amendment. The district court here says that there is a distinction between police power on the one hand and eminent domain on the other hand, and that these two things do not necessarily overlap. For reasons discussed below, we reject these arguments and affirm the district court's order. With that out of the way, let's consider the specific facts in this case and how they gave rise to the incident at hand. Leo and Alfonsia Lech purchased their home at 4219 South Alton Street in Greenwood Village, Colorado for their son, John Lech. Incidentally, someone buying your home for you is nice if you can get it. On June 3, 2015, officers from the city police department responded to a burglary alarm at the Leches' home and learned that Robert Seacat, an armed criminal suspect who was attempting to evade capture by the Aurora Police Department, was inside. To prevent Seacat from escaping, the officers positioned their vehicles in the driveway of the Leches' home. Seacat then fired a bullet from inside the garage and struck an officer's car. At that point, the officers deemed the incident a high-risk barricade situation. For approximately 5 hours, negotiators attempted to convince Seacat to surrender. After these efforts to negotiate proved unsuccessful, officers employed increasingly aggressive tactics. They fired several rounds of gas munitions into the home, breached the home's doors with a Bearcat armored vehicle so they could send in a robot to deliver a throw phone to Seacat. I do love how the name of the armored vehicle is Bearcat and the name of the suspect is Seacat. This truly was a match made in heaven. And then used explosives to create sight lines and points of entry into the home. The officers also sent in a tactical team to apprehend Seacat. When even these more aggressive tactics failed to draw Seacat out, officers used the Bearcat to open multiple holes in the home and again deploy a tactical team to apprehend Seacat. Bearcat and Seacat fight! This time, the tactical team was successful. It managed to disarm Seacat and take him into custody. But as a result of the 19-hour standoff, the Leches' home was rendered uninhabitable. And although the city offered to help with temporary living, expenses when the Leaches demolished and rebuilt their home. It otherwise denied liability for the incident and declined to provide any further compensation. So here we see that the damages to the home apparently resulted in a total loss to the home. The homeowners decided to raze the house to the ground and rebuild it from scratch. So the damage was so extensive that they decided that this was the most prudent course of action. Whether or not it was truly necessary, I don't know, but it is what actually happened. So they lost all the value in their home. The question is, should anyone have to pay for this? The city and the police said no, and that's why they brought suit to try to get recovery. Let's see what happened next. The Leaches then sued the defendants, alleging in relevant part, defendants violated the taking clause of both the United States and Colorado constitutions by damaging the Leaches' home without providing just compensation. The district court rejected this argument. In doing so, it first distinguished between the state's eminent domain authority, which permits the taking of private property for public use, and the state's police power, which allows it to regulate private property for protection of public health, safety, and welfare. So, as we were discussing a little bit above, there is a distinction between police power, which is the general power of the government to regulate and enforce all kinds of regulations and laws, and the more specific word of police, as you might know it in terms of police officers. Police officers are one type of police function, but police power is much broader than the police function as you might know it. Police power goes to the ability of the government to regulate and enforce its regulations, and basically the ability of the government to act in general. So they're saying there's a distinction between eminent domain authority, where private property is being taken for public use, and this police power, which is a more general taking for police functions as are relevant here. Next, the district court determined that the state's police power encompasses the enforcement of a state's criminal laws. And because the officers damaged the Leaches' home while attempting to apprehend a criminal suspect, the district court reasoned their actions fell within the scope of the state's police power and not the power of eminent domain. Thus, the district court concluded any damage the officers caused to Leach's home did not constitute a taking for the purposes of the taking clause. According to the Leaches, the defendant's conduct amounts to a taking because the officers physically intruded upon and ultimately destroyed their home, and such a physical appropriation of property gives rise to a per se taking. The defendants, on the other hand, argue that no taking occurred because the officers damaged the Leaches' home pursuant to police power, not the power of eminent domain. On appeal, the Leaches first argue the district court erred in drawing a hard line between those actions the government performs pursuant to a power of eminent domain and those it performs pursuant to the police power. The Leaches do not dispute the Supreme Court has recognized such a distinction in the context of regulatory takings, where the Supreme Court distinguished between the state's power of eminent domain, under which property may not be taken for public use without compensation, and states' police powers, which are not burdened with the condition the state must compensate affected individual owners for pecuniary losses they may sustain. But the Leaches suggest this distinction is not dispositive in the context of physical takings. So there's quite a lot of information here where the court is illuminating this issue, and the court is quite right. In these kinds of cases, there have been situations where governments have done things in order to promote progress. For example, laying cable lines, laying power lines, that kind of thing. And they might have to do it by going under someone's land or over someone's land. And people have, from time to time, argued that these kind of things are taking because it is taking part of their property right by burying cables or putting cables above their land or whatever the case may be in order for some governmental purpose. But broadly speaking, the United States Supreme Court has ruled in the past that these kinds of regulatory takings are not takings for the purposes of eminent domain authority. These are police power takings, and therefore they do not require compensation. So if the government is laying cable lines or laying power lines or something similar to that, that has been deemed a regulatory issue, not an eminent domain issue. And so that is the kind of distinction the Supreme Court is elucidating. But contrary to the Leach's position, at least 3 of our sibling circuits and the Court of Federal Claims have expressly relied upon the distinction between the state's police power and the power of eminent domain in cases involving the government's direct physical interference with private property. So here the Court of Appeals is noting that 3 other courts of appeal and the Court of Federal Claims, which deals with claims specifically against the federal government, have all ruled that there is this distinction in sort of parallel claims. So this is what they're relying on in their analysis as well. Further, although the Supreme Court has never expressly invoked this distinction in a case alleging a physical taking, it has implicitly indicated that distinction applies in this context. For example, see a case called Bennis, rejecting a plaintiff's taking cause claim where the state ordered a vehicle forfeiture as a public nuisance without requiring the state to compensate the vehicle, who shared ownership of the vehicle with her husband, reasoning that when a state acquires property under the exercise of governmental authority other than the power of eminent domain, government is not required to compensate an owner for that property. So here there was a vehicle that was so annoying, the government said that they're going to take it off the streets. But that is not considered eminent domain. It's not taking within the context of public use within the meaning of Fifth Amendment. Rather, it's taking as a result of police action, as a result of them violating the relevant rules when it comes to what are and are not operating vehicles in this particular situation. So because they were in violation of the rules, the car was taken and no compensation is due, even though it's a physical taking of a property. The Leches urge us to disregard the distinction between police power and the power of eminent domain in resolving this appeal. In support, they point out that the Takings Clause was designed to bar the government from forcing some people alone to bear public burdens, which in all fairness and justice should be borne out by the public as a whole. We do not disagree that the defendant's actions benefited the public, but as the court explained in Mugler, where the state acts to preserve the safety of the public, the state is not, and consistent with the existence and safety of organized society, cannot be burdened with the condition that the state must compensate affected property owners for pecuniary losses they may sustain in the process. Thus, as unfair as it may seem, the Takings Clause simply does not entitle all aggrieved owners to recompensation. So this in large part makes sense. When the government is taking something in order to promote safety, for example, they're not taking it for private use within the meaning of the Fifth Amendment. They're not taking it to build a highway. They're not taking it to build a school. They're not taking it even to build a shopping mall, as was in the case of Kilo, for example. Rather, they're taking it for the purpose of enforcing public order and safety. And in that situation, no compensation is due because they're taking it for that purpose. A similar situation would occur if the fire department blew up a person's home in order to use it as a fire break. If a fire was going down a series of row homes and the fire department blew up a house in order to create a fire break, that would stop the fire. But that situation would not cause the government to have to pay compensation because they're not taking it for public use within the meaning of the Fifth Amendment, rather taking it in order to prevent the fire from spreading. Or in this case, on bar, in order to apprehend the suspect who happens to be inside the place. They're not taking it because they have anything against the house. They're taking it in line with the standard police function. So whereas the fire department blowing up a house to create a fire break, or the police department busting down the door in order to apprehend a suspect, no compensation is due because it is not an eminent domain action. The police power encompasses the authority to provide for public health, safety, and morals. But as discussed above, we have described police power in contrast to the power of eminent domain. The former controls the use of property by the owner for public good, where the latter may take property for the public use. The Court of Federal Claims addressed the potential distinction between cases in which law enforcement seize and retain personal property as suspected instrumentality or evidence of crime, and cases where government officers inflict damage to real property that is incidental to the exercise of police power. We likewise reject the Leach's assertion that the police power does not encompass the state's ability to seize property from an innocent owner. This argument is not without support. See, for example, Wegner versus Milwaukee, holding that where an innocent third party's property was damaged by the police, in the course of apprehending a suspect, such damage was inflicted for public use. Nevertheless, despite the considerable appeal of this position as a matter of policy, we join the Federal Circuit in rejecting this argument as a matter of law. So long as the government's exercise of authority was pursuant to some other power other than eminent domain, then the plaintiff has failed to state a claim for compensation under the Fifth Amendment. The innocence of the property owner does not factor into the determination. So that is the case of Leo Lech versus the City of Greenwood Village. So in this case, we learn the distinction between police power and eminent domain authority. And it looks like Leo Lech and his family may just be plumb out of luck. I'm assuming the fact that they had to sue the government here means that any home insurance that they did have refused to pay because of the police action. So it looks like they may be out the value of their home, because it looks like their home insurance didn't cover it, because why would they sue the government if they did? And it looks like the police won't cover it either. So short of some sort of community offering, they will be out the value of their home, which is, of course, not insubstantial. But the Court of Appeals does cite relevant precedent here in pointing out that there is a distinction. And as we discussed, this is a distinction not only as it relates to police, but also to fire and other sorts of emergencies. So if in pursuit of trying to fix some emergency, the police or other authorities cause damage, that is not taking within the meaning of eminent domain. This is in line with the precedent, and so that is the end of this case.